When you file a Chapter 7 petition, or as a matter of fact, a petition under any chapter, that act triggers a stay. You don't have to do anything else. So it's called the automatic stay. In law, a stay says stop. Whatever stayed has to stop immediately. And in this case, what stayed or stopped is all action by creditors against you as a person, against your possessions, and against the bankruptcy estate that's created when you file your petition. So in practical terms, it means they can't call you on the telephone, send you bills, write you letters, sue you, garnish wages, seize money out of bank accounts, foreclose on property, repossess property. In essence, what it does is it erects a legal brick wall around you to protect you from the depredations of your creditors. And if a creditor violates the stay after it's received clear notice, you can sue it in the bankruptcy court. And if you're successful, they have to cover your court costs and attorney's fees, something that's near and dear to a bankruptcy attorney's heart. And by the way, that's unusual in American jurisprudence. Generally, each side covers its own costs and attorney's fees unless there's an enabling statute or a pre-existing contractual right. In this case, the bankruptcy code has an enabling statute. So it will rake flesh off of creditors if they violate the automatic stay. So if a creditor is violating the automatic stay and you're my client, I want to know right away. Now, occasionally it's an honest mistake on the part of the creditor. I don't attribute malice to each creditor. So as a prophylactic, I will send a letter to that creditor saying, my client's in Chapter 7, please comply with the automatic stay, and I'll also give them a call. So I've got this on record. Once in a while, most creditors are pretty okay with this, but once in a while I'll get an obstreperous creditor that just keeps on pushing. Well, if that happens, then we push back hard and we will sue them in the bankruptcy court. But generally, you will find that after you file that petition, a deafening silence will have come over your telephone. They're not going to harass you anymore. And if they do harass you, it's not necessarily a bad thing. Now, after you get your discharge, that automatic stay terminates and it's replaced with a permanent discharge injunction that I mentioned earlier. So once that happens, any debts that were discharged in the bankruptcy, the creditor can never try to collect again. And if they do, we go back to the bankruptcy court and sue them. Now, keep in mind, if there were debts that were not discharged, then the discharge injunction does not prevent them from coming after you to collect those debts. Maybe a typical example is an obligation to pay child support or alimony. Or perhaps you have certain tax debts. Some tax debts are dischargeable, but most are not. And if you have a non-dischargeable tax debt, you can be sure the taxing authority is going to continue to try to collect from you because that debt was not discharged in the bankruptcy. But generally speaking, creditors will not bother you. And by the way, that even includes the IRS. The automatic stay is binding on the IRS just as much as it's binding on Citibank or Chase or any of these other creditors.